afternoon. I'm Jane Brennan, one of the vice presidents of the League of Women Voters of Central Delaware County. I'm very happy to welcome all of you to our today's hot topic presentation, Legal Aspects of Healthcare for Seniors. The mission of the League of Women Voters is to encourage informed and active participation in citizenship, elections, and democracy. The League of Women Voters is a nonpartisan political organization that encourages informed and active participation in government and influences public policy through education and advocacy. The League of Women Voters neither opposes nor supports any party or candidate. And before I introduce today's speaker, I'd like to share with you the upcoming events that the League of Women Voters of Central Delaware County is offering or supporting. Tomorrow, on May 13th, there will be an environmental town hall sponsored by the Get Out the Vote team, and that will be at the Beverly Hills Middle School in Upper Darby, off Garrett Road. On May 19th, which is Friday, there is another hot topic program, this one organized by our Civic Education Committee, entitled "The Court Has Spoken on Pennsylvania School Funding. Now What?" It will be a Zoom program, and it will start at 12 noon. On Friday, June 2nd, we'll have another Zoom program, "Healthcare Fraud Costs Us All, and Not Just Money." Our guest speaker will be Jodine Mayberry via Zoom at 12 noon. On Tuesday, June 6th at 7:30 p.m., we will have our League of Women Voters Central Delaware County annual meeting. You are all invited and encouraged to attend. And from June 16th to June 18th, the League of Women Voters of Pennsylvania will have our convention at the Crown Plaza Hotel in Harrisburg. You can register for any and all of these events by going to our webpage, lwvcdc.org. And now I would like to introduce our guest speaker. Our guest speaker for today is Jennifer Simons, an associate attorney with McAndrews Law Offices in Malvern. Her areas of practice include estate planning, special needs trusts, elder law, guardianship, and estate administration. Ms. Simons is a graduate of Widener University, Delaware Law School, and Philadelphia University. In a previous life, before becoming a lawyer, Ms. Simons had a decade-long successful and award-winning career in the business community, working for national companies in major positions involving commercial analytics and coordinating multiple activities in sales, marketing, and management. The questions that were submitted prior to the event have been shared with Ms. Simons. As moderator, I will share these and any other questions that may be sent during the chat function, by the chat function during the program. So without further ado, welcome Jennifer Simons.
Thank you. And good afternoon, everybody. Thank you for joining on a beautiful Friday, which is probably during everybody's lunchtime. So thank you for taking the time to join the presentation today. A little bit of background. I have been with McAndrews Law Offices for 10 years now. I had my 10-year anniversary a month or two ago. So I have been there quite a long time, and the areas that I practice in primarily are estate planning, special needs trust, public benefit, guardianship, and estate administration, and some elder law. So I'm happy to be here today, and we are going to be talking about legal aspects of when it comes to seniors. And I'll be talking about a couple different documents that I think everybody should have, regardless of whether you're a senior or not, but especially if you're an older adult. So why don't we go ahead and begin? And I'm going to try to advance my slide here. Okay. So there are a couple of documents that I feel are documents that are really important for like I said, everybody to have, but especially if you're a senior or an older adult. And the three main documents that we usually recommend to clients are a power of attorney, a living will, or sometimes referred to as an advanced medical directive, and a will. A will is not necessarily referring to healthcare, but I think a will is really important for everybody to have. So I'm going to briefly touch on that more towards the end, since it isn't really a healthcare document, but again, just an important document for everybody to have. And while I'm talking, I'm going to be referring to a couple of different terms, legal terms. So I wanted to talk about what they are, just so everybody has an idea of what I'm referring to. And so the first one is a principal, and that refers to a power of attorney. When you create a power of attorney document, I'll go into what that document is and explain it, but the person who creates the document is called the principal. And the agent is who you are appointing to act for you, whether it's financial or medical matters. That is your power of attorney agent. And then a declarant, when we talk about a living will, the person who creates a living will is the declarant, and the surrogate is whoever you've appointed to make decisions for you under a living will. And again, I'm going to go through each of these documents, but I wanted to just talk about the terms before we get into it. So the first document that I want to talk about is the power of attorney, because I really do think that that is one of the most important out of all the documents. And basically, a power of attorney document is a written document where you are giving another individual the power to act for you, to make, whether it's financial or healthcare, to make decisions on your behalf if you're not able to. In order to create a power of attorney, an individual has to have the required capacity to do that. Every type of legal document has a little bit of a different requirement when it comes to capacity and the type of capacity you have to create that, whether it's a will, a power of attorney, a trust. But for a power of attorney document, in order to have sufficient capacity, you have to have a general understanding of what that document is, meaning you have to understand the type of power that you're giving to your agent in order to handle, whether it's financial matters or make medical decisions or any type of power that's in the document. And then you have to be what's called oriented to person, place, and time. And all that means really is you have to have an awareness of what is going on. What is your name? Where do you live? What's your birthday? Who are your family? Just have an idea of your surroundings, and again, just all of your basic information, and be aware of what you're doing. And there are a couple different types of power of attorney documents. A durable power of attorney is the most common, and that's typically what I prepare when I'm preparing a power of attorney for clients, depending on each individual client. But for the most part, it's usually a durable power of attorney. And all that means is that if after you sign a power of attorney, if you later become incapacitated, that document is going to remain in effect. And your agent will still be able to, handle all matters for you and make all decisions, even if you're later determined to be incapacitated. There's another type of power of attorney document where that does not go into effect until you are incapacitated. And I'll talk about that in a moment. But so there are also different types of powers of attorney. You can have a financial power of attorney, or you can have a medical, or you can have both. If you're going to name the same person to make medical and financial decisions for you, then, it's probably, best to do a combined financial and medical document. And again, that's if you're naming the same person. But a lot of times clients have different people. They may want to have one person handle all of their financial stuff, and then they want to have another person handle all of their medical. I've run into that a lot with clients when, if they're naming their adult children, sometimes they have one child who's really good with money, who's really good with all the financial stuff, and then they may have another child who maybe is a nurse or in the medical field, and that child is going to be better with handling any medical decisions. So it really depends on who you're naming and what type of decisions that person is going to make, whether you need one document or whether you need to have two different documents. So a few moments ago, I talked about the springing power of attorney. That's a document that does not go into effect until a doctor determines that a person is incapacitated and not able to make their own decisions. The durable power of attorney, once you sign that document, that goes into effect right away. And that would give your agent the ability at that point in time to act for you if need be. People sometimes need their power of attorney agent to act for them, even if they're not incapacitated. For instance, if you were going to be out of the country for a little while and you wanted your power of attorney agent to be able to handle financial matters for you, if you had a springing power of attorney, they wouldn't be able to do that because you have to be incapacitated before that would take effect. So I would say most times we're creating durable powers of attorney for people, unless there's a reason or a concern that they have where they wouldn't want that document to go into effect immediately. With the springing power of attorney, there can sometimes be a delay by the time that you need to have a doctor. It takes time for a doctor to evaluate the person and determine whether they're incapacitated. And during that time, your agent's not able to do anything for you. So the durable power of attorney, I think in most instances is probably best, but because again, your agent would have the immediate ability to act for you. And so a lot of people ask, well, what can my agent do for me as a power of attorney? What type of decisions are they able to make? And it really depends on what is in your document, what specifically is in your power of a document, what power does the agent have. But in general, I listed a couple of examples of what your power of attorney agent can do for you. And in terms of healthcare, they'd be able to authorize your admission, whether it's to a hospital, a medical facility, a nursing facility, or something similar to that. They'd be able to make any type of healthcare decisions for you if you couldn't, to authorize a medical treatment or procedures. They'd be able to communicate with doctors on your behalf and get your medical information. As you know, if you haven't appointed somebody to be able to get your healthcare information to talk about that with a doctor, then they're not going to be able to do that. But that is something that they'd be able to do as a healthcare power of attorney. In terms of a financial power of attorney, that person would be able to handle pretty much any type of financial transaction, whether it was real property had to be sold, they'd be able to handle that, paying your bills, writing out checks, handling your bank account, making gifts on your behalf to, if need be, if appropriate, and then handling any type of other transaction, whether it's, dealing with your insurance company, changing beneficiary designations of a policy if appropriate. So it really, like I said, they have, especially the financial power of attorney, you are giving somebody a lot of power in regard to handling your finances. So you definitely want to be careful about who you pick and make sure that you trust the person who you're naming. Okay, and as your agent, they have they have a duty to you. They need to make sure that they are exercising their power for your benefit. And that means keeping any of their money assets separate than yours. They should not be commingling your money with their money. And, in everything they do, making sure that they use, reasonable caution and prudence, and keeping good, accurate records of everything that they do, just in case they ever needed to account for how they handled your money. They need to have receipts, paperwork, all of that. If they ever had to do any type of accounting. And I wanted to talk a little bit about power of attorney versus guardianship. Because if somebody has not already executed a power of attorney document, and if they later become incapacitated and they're not able to make decisions, and it's essentially too late to create that power of attorney document, then it's possible that there would need to be a legal guardian appointed for the person. And that is really the last alternative that you would ever want to consider. Is as long as somebody has the ability to do a power of attorney, you want to make sure that that is first done. But like I said, if somebody has not done that and then they later become incapacitated and they're not able to, then if there are things that need to be done on your behalf, especially I think if there are financial decisions that need to be done or handled, if your bills need to be paid, then you may be looking at a legal proceeding through the court, which guardianship is a legal proceeding through the court, where you file a petition. Somebody would file a petition on your behalf and ask that the court appoint a legal guardian for you to handle, whether it's your finances, a guardian of the estate, or any other type of healthcare, any other type of decisions regarding your person. That would be guardianship of the person. So again, that is guardianship. You need, before you would petition a court to have a guardian appointed, you want to make sure that you've considered any other possible least restrictive alternatives. And in addition to a power of attorney, one other alternative, and I'll go into this a little more in a few moments, but would be having a healthcare agent who would be able to make decisions for you if you didn't already have a power of attorney agent appointed. So that's essentially what a power of attorney document is. It's a document where you're giving another person the ability to make financial or medical healthcare decisions for you. Now I wanted to talk about an advanced medical directive, or it's sometimes referred to as living will. They're essentially the same thing. And what that is a document where you appoint, again, another person to make end of life decisions for you. That is the difference between a healthcare power of attorney and a living will. The living will is only going to come into play when you're in an end stage medical condition or a permanent state of unconsciousness and you're incapacitated. And basically you are setting out what type of treatment you would want if you're in that end stage medical condition or permanent state of unconsciousness. and your agent would be making any type of end of life decisions for you. In contrast to the healthcare power of attorney, that's more for, maybe day-to-day healthcare decisions, or any time where maybe you have an illness, but you're expected to recover. That's where your healthcare power of attorney is going to be able to make those healthcare decisions. But again, with the living will, this is when a doctor has basically, stated that they believe that you are not, you're not going to get better. This is an end of life condition, and it's not likely that you're going to recover. So that a lot of people get confused between the healthcare power of attorney and living will, and kind of interchange them, but one is really for only end of life, and the other one is for all other types of healthcare decisions that when you can't make them on your own. And like I said, when I talk about being unconscious, basically that's when either, you may be in a coma or some type of vegetative state where it's permanent and you're again not likely to recover from that, or if you're in an end stage medical condition. And like I said, that's where a doctor has said with a reasonable degree of medical certainty that you're probably not going to get better. And any type of treatment is merely, you're not going to recover by treatment. It's just going to prolong the dying process. And then one thing that I wanted to talk about, and this was a topic that was requested to talk about, is a POLST order. And a POLST order is a medical order. So it's not a legal document. An attorney does not create a POLST. A POLST is, a physician's order for life-sustaining treatment. And it is an order by a doctor that determines what type of treatment you want when you're nearing, when you're pretty near to that end of life stage. And it's a form that you would complete, usually working with your doctor. And again, just what type of treatment do you want at that point? This is not something that's used until you're, you're getting pretty close to end of life. The person who creates a POLST is not somebody who may be newly diagnosed with a progressive illness, or maybe they're disabled, but they're expected to survive at least a year or more. This is really for that very end stage of life. And the order goes with you. So if you were to go from one facility, whether it's a hospital or a nursing facility, that order travels with you so that everybody is aware of the order. And I believe they're typically printed on pink paper so that they're easily able to be identified, and you're not looking through papers. The doctors are not trying to find what order that is, but that is a POLST order. I don't usually spend too much time talking about that because it's not a legal document. It's not anything that an attorney would prepare for you. It's more of a medical order that you would talk about and create with your doctor, and your doctor would sign it. But it is something to think about if you are in that end stage, end of life nearing. And then one of the questions that I think people had was, who would have the legal ability to make end of life decisions if you don't have anybody already appointed, if you don't have if you didn't create a living will, you didn't create a healthcare power of attorney, who would be able to make any decisions for you? And Pennsylvania does have a law, the Pennsylvania Healthcare Agent Statute, which I have up on the screen here. I have the language from the law, but basically it sets forth a priority order of people who would have, the ability to make those decisions for you. Again, if you haven't already appointed somebody to do that. And generally, it's going to be your next of kin. And I have up here what the order is in the law. And, essentially, it's going to be a spouse. If you don't have a spouse, an adult child. If you don't have an adult child, then a parent, a brother or a sister. If you don't have any of those, then an adult grandchild. And if you don't have any of those people, then it would be any adult who knows what you would want, who has an idea of what your preferences would be regarding end of life treatment and or healthcare in general. Whether it's based on your religious or moral standards, somebody who knows what you would want. If there's no other family member that's available, then a doctor is probably going to look at anybody who knows what you would want. So, there is a legal way for other people to make healthcare decisions if you don't already have a power of attorney or a living will. But again, I would stress the importance of already appointing somebody because you're appointing them. If you haven't appointed them, then it's going to go by the law. It's going to go in this order, and maybe you wouldn't want one of those people to make your healthcare decision. So by doing a power of attorney and living will, you have the ability right now to appoint who you want to make decisions for you. But in the absence of that, and if all else fails, then the Pennsylvania healthcare statute would really dictate who would be able to make those decisions for you. All right, so I've gone through the basic documents when it comes to healthcare and who can make decisions, who you can appoint to make healthcare decisions for you. As I said, I wanted to talk a little bit about wills because I think that they're really important to have. In addition to the power of attorney and the living will, a will is really important. So a will is a written document where you state who you want to receive property, any property that you own at your death, who you want to get that property. It can also provide for who you would want to be executor of your estate. And that's the person who is going to handle the administration of your estate when you die. They're going to be the one who collects all of your assets, pays all of the bills, files the Pennsylvania inheritance tax return, and then in the end distributes everything to who you've named as the beneficiaries of your will. A will can also appoint a guardian if you had minor children, a guardian for your children. We can set up a trust, if there was a need for a trust. So, but basically the will is so that you have the ability, again, to say, this is who I want to get anything that I own, rather than have it dictated by the law. And I'll go into that in a minute. And so the most important reason, in my opinion, to have a will is so that your estate does not pass through the intestacy laws of Pennsylvania. And that is how your estate would be distributed if you didn't have a will. Similar to that healthcare statute, there is an order of who would be entitled to receive your estate if you don't have a will in Pennsylvania. It's the Pennsylvania intestate laws. And it's, I'm not going to go through each situation because that can get very complicated and detailed, but it's like a next of kin order, basically. And that's what happens if you don't have a will. It's going to be dictated by the law, who under the law is entitled to receive your estate. And again, it may not be the person that you would want to get your estate. If you don't want maybe a sibling, maybe you don't want one of your siblings to get your estate, if you don't do a will, And if they happen to be in that priority order, it's kind of out of your control at that point. So I think that's the most important reason to do the will, so that you get to dictate who receives your property. And again, the other reason, like I said, is to be able to choose your executor who is going to handle all of that, who's going to handle all the paperwork that's involved when a estate is being probated. Another reason may be if you have children who are disabled and maybe they're receiving public benefits, you may want their share of your estate to go to a special needs trust and not to that person individually, because that could potentially affect their eligibility for public benefits. In order to create a will, basically you just have to have, you have to have the intent to make a will, that this is what you're doing. You're specifically stating who you want to receive your property. You do have to be of sound mind. Generally what that means is that you have to have an understanding of what is your property, what property do you have, who is your next of kin, who are your family members, and that when you're creating the will, that you are basically stating that these are the people who are to get your estate when you pass away. So again, you have to have an understanding of what all of that means. And the requirements, for executing a will is it needs to be signed in front of 2 witnesses and in front of a notary in Pennsylvania. Everything I'm referring to is Pennsylvania law. And one question that we get a lot is, how do you pick your executor? Who should you choose to be the executor of your estate? And this is going to be the person who takes your will to the Register of Wills. They will take your original will when you pass away. They will be officially appointed as the executor of your will by the court. And then that gives that person the legal ability to begin collecting your assets. They will, be able to go to the bank to, have access to your bank accounts, and they'll open an estate bank account where all of your money, all of your assets will be deposited into the estate bank account. And they will then begin paying any bills that need to be paid, any funeral expenses they will pay. The inheritance tax. Pennsylvania has an inheritance tax that needs to be paid. So they will be doing that. And then after all of that is done, whatever money is left, called the residue of your estate, then they will distribute that to all of whoever you've named as the beneficiary of your estate. So that is what the executor will be doing. And so the person that you pick, you want to pick somebody, first of all, who is going to agree to take that on. It can be a big job depending on the size of your estate. They can hire an attorney. A lot of people ask if they can do it on their own. Do they need an attorney to handle that? And you don't need an attorney. If somebody is able to, and if they're capable of handling the estate on their own, they don't necessarily need an attorney. But a lot of people do end up having an attorney help, especially with the Pennsylvania inheritance tax return. That can be somewhat, little complex and complicated to prepare. So somebody who's able to do all of that, somebody who's good at keeping good records, details, who's trustworthy. You also may want to think about where they live. Well, you can have an executor who lives in another state. It's probably easier if they're in Pennsylvania. A lot of things now can be done electronically. Even, we've had clients now that have been appointed as an executor in another state doing a Zoom call, basically. So it's not that you necessarily have to travel as much nowadays as maybe you did before to be executor. But location is something to think about. And then, what do they have a good relationship with the people who you've named as the beneficiaries of your will? Because they'll be having to, possibly communicate with these people and work with them. Maybe you don't want to appoint a relative who is not on good terms with the family or, with the beneficiaries. Think about who's going to be able to get along, everybody kind of get along. So that would be my thoughts on when you're trying to think of who to appoint as the executor. And then once you've prepared your will, once you've actually, created a will, it's important to make sure that you look at it every now and then and make sure that it's updated when it needs to be. Generally, I'd say to take a look at your will at least once a year, but definitely if you have any major change in your family, if there's been a divorce, a birth, a marriage, death, any type of big change, a change in the amount of your estate. If you move to a new state, you may not need to do a new will. It really depends, but it's always a good idea to have an attorney in the new state take a look at your estate planning documents and make sure that they would be valid in the new state. So if you move, it's a good time to look at everything. If there's any changes in the tax law, maybe at that point you might want to, look at some type of doing some type of tax planning. But anytime there's any type of big major change or, life event is a good time to look at your will and see if it needs to be updated. And I think I pretty much went through what happens. What is your executor going to do when you die? Like I said, they're going to take your original will. And it's a good idea to let your executor know where you have kept your original will. They will need the original. They need to take the original document to the register of wills and not a copy. If they really don't have the original and they have to present a copy, it can be done, but it usually requires a petition to be filed with the court to approve the copy of the will and not the original. So it's really important to keep your original will in a safe place, maybe in a fireproof box or safe, and let your executor know where that is so that they're able to go and find that when the time comes. And I just went through all, what they do from that point on regarding opening the estate account, paying all of the bills. Once all of that is done, then again, whatever money is left at that point is then going to be distributed however you have dictated in your will to the beneficiaries. And then after everything's done, the executor files a final report with the court, letting the court know that the estate is now closed and everything essentially has been taken care of. I probably forgot to mention, one other thing, if you happen to own real property when you pass away, the executor will probably have to make arrangements to sell that property. If it wasn't left to, if that specific property wasn't left to a beneficiary, typically the home will be sold and then the proceeds would be distributed to the beneficiaries of the will. That was just something I forgot to mention. One other thing is that when you do a will, a lot of people don't realize that there's probate assets which pass under your will, and then you have non-probate assets which are going to go directly to whoever you have named as the beneficiary. And typically the non-probate assets are things like your 401k, an IRA, a life insurance policy, anything where you've already named who is going to get get that account when you pass away. That will not be distributed under the terms of your will. So sometimes when people do a will, most people want to have your estate pass the same way, whether it's your probate assets or your non-probate assets, that you want it to be distributed in the same way. So you need to make sure that if you do a new will, you may want to think about whether you have to change those other beneficiary designations, like your IRA, your 401k. Make sure that that matches how your will states that the property should be distributed. Sometimes people forget that not everything is going to fall under your will. You're going to have accounts that just go to directly whoever you have named, even if your will is different. So you just want to make sure that they match, or at least they are who you want, the beneficiaries who are named are the people who you want to receive that property. That is basically the bulk of what documents I think are important, the most important documents to have. So if, we'll definitely, go through questions. But if you had any further questions, or want to, you want to contact me, I have my contact information up there. You can email me. If you think of a question later, you can email me. If it's a very straightforward question that I can answer pretty easily, then, I will just answer it. However, if it's a little more complex and, we may need to do a consult for a more complicated, lengthier question. But if it's something easy, I can definitely try and just answer it in an email. But I'm happy to, to answer any questions right now. I think I covered a few of them through the presentation, but
we've gotten
Jennifer?
several more
okay.
in the chat. One is, what about a living trust rather than a will?
Mm-hmm. Yeah, some people, typically the reason that you would want to do a living trust, sometimes referred to as a revocable trust, is usually if you're trying to avoid probate. And in Pennsylvania, probate is really not particularly difficult. It's not very expensive to go through probate. A lot of times people think that if they do a trust, that's going to avoid taxes. And that's not the case. You're still going to have to pay, Pennsylvania inheritance tax. But when a trust might be helpful is if you own property in another state other than Pennsylvania, because if you own property in another state, then whatever is owned in that other state is going to have to go through the probate process in the other state and not through Pennsylvania. So your executor may have to go through probate in Pennsylvania and another state. And it may depend on, again, how complicated is probate in that other state, whether it's worth doing a trust. So that basically what would happen is if you have a trust, you could then have to transfer all of your assets into that trust, because that's the whole point, is that when you have a trust, you avoid probate because everything you own is in the trust, and whoever you've named as a beneficiary, they will automatically, get that property. So, at most times, I think people, probably don't need a trust for all of their assets. But it depends on each individual situation. Like I said, if you do own property in another state, that may be a reason. If you have other concerns about, the people who are receiving the property, if there's a reason you want to have it continue to be in trust, you could also create a trust under your will, which would not be a living trust. But in general, I think it's usually most useful if you're in a state where you're really trying to avoid probate because it's going to be extremely, either complex or expensive, or if you own property in another state.
Okay, thank you. We have a question about what are the pros and cons of POD or TOD on checks?
So a POD basically is a pay on death bank account, meaning that when you pass away, that is automatic. Whoever is named as the beneficiary of that account is going to automatically go to that person, and that can be a good thing if, again, that wouldn't go through probate. So it would just, whoever you have named to get the money in that account when you pass away, they would get it. It really just depends on each individual situation, the reason for doing that. If you have other children, you may not want to have one account that's a pay on death to one child, because then, those other children aren't going to get that share of your estate, the money in that account. But it can be a good way if you want to try to avoid, going through probate. That would just pass to whoever is named as the beneficiary of the account.
We also have a question. Does a spouse automatically have the rights and responsibilities of a power of attorney?
No. So that's, typically when we do a power of attorney, we're naming the spouse as the primary agent. Usually, the husband is naming the wife is naming the husband, but, absent creating that power of attorney, they wouldn't automatically have that right unless, we talked about that priority order. If you don't have power of attorney, then typically, if you're married, the spouse would be that first in the order of priority, the first person able to make those medical decisions for you.
There is also a question about if there are two or more persons in a priority class, like children, how are disagreements between or among them resolved?
Yeah, so I'm assuming that means that you haven't already, I'm assuming the question means that you haven't named the children as agents, or even if you have named them as agents. First of all, it's going to depend on what the document says. If they've named all children as equal co-agents, then, my understanding is that it would, go by a majority, with the majority of children, what they want to do. I think it involves talking with the doctor, also the doctor trying to, explain the differences in treatment and try to maybe help everyone come to a unanimous decision. But I think ultimately, if, and what's in your living will, if you created a living will, they're going to look at what is your preference. And, but ultimately, I think if you can't come to an important medical decision, it possibly could end up in court. If the children can't agree, or whoever would be entitled to make, again, there's that priority order. So if there's somebody above the people who are trying to make that decision, they would have the first priority.
Okay. And we have a comment. As an executor, one of the hardest issues I had to deal with was the post office. I found that I needed a death certificate. I'm not sure if it was just a comment or a question.
Yeah. I don't know.
With regard to death certificates, do you recommend ordering a certain amount at the time of death when you're?
Yeah, you're usually going to need a number of copies of the death certificate. I'd say, I think I usually say between maybe 10 and 15. It depends really who you need to give, if you have creditors, you're going to have to give a copy, not to creditors, I'm sorry, but to banks. you're going to need to give a copy to handle that person's account. You're going to need to give copies to any insurance company. So I'd say maybe 10 to 15.
Is
Just
a
a
good number.
number.
Ironically, I found that I had to submit a death certificate to change our Easy Pass from New Jersey to return it and cancel out that account. They wanted a death certificate.
Okay. Yeah, I mean,
That
that's
was weird.
that's one I haven't heard of, but yeah. Yeah, anytime I guess you're trying to do something on behalf of the deceased, you may be asked to present a death certificate. If you don't have them, you can always request more if you end up needing more.
We have one other question about, can a nursing home evict, for want of a better word, a patient who runs out of money?
Yeah, I saw that question. In general, what I would say is that if you are in a nursing home and you run out of money, you're going to have to apply for Medicaid in most cases, because Medicaid is going to, basically start paying when somebody runs out of money. It can be a whole complicated, more like elder law conversation on this, but in general, if you run out of money, either your power of attorney or whoever is basically the person who's helping you at that point, maybe it's an adult child, they're going to have to work with the nursing home to apply for Medicaid on your behalf and basically cooperate in filling out the paperwork and any information that Medicaid requires. But, they're not going to put you out on the street, but there's going to be a process of making sure that there are no, other assets. You have to, if you qualify for Medicaid, you have, obviously you have limited assets at that point to qualify. And there's Medicaid planning you can do. But that's a whole other topic. But in general, Medicaid is going to pay when people can't afford the nursing home anymore.
We have another comment about the need for death certificates. One of our members said, I just sold my dad's house. He is medically incapacitated, and I needed to submit a copy of my mother's death certificate. She had passed away over 13 years ago.
Mm. Yeah, I mean, it's definitely, maybe required.
So I think that's the end of the questions we have. I'd like to thank you, Jennifer, very much for your very helpful presentation. We did have a question about how do you, is there a way to broach the subject of wills and advanced medical directives with people who are reluctant to discuss it?
Yeah, that's
family members in particular.
That's a really good question. And what, I probably should mention that in the presentation. A lot of people, and myself included with my family, don't like to think about that, don't like to think about death and talking about doing a will, and who, it's just a topic that people don't want to talk about. But what I would urge people to do is to, maybe even have like a little family meeting, perhaps, and kind of approach it as you want to be able to make these decisions while you're alive. And, like I said, with a will, if you don't do a will, your property may not go to the people that you intended it to. It's going to go to whoever legally is entitled to it under the law. So for me, that's been a really good reason, when I talked to people, and myself included, when I did my will, it was because there were some people I didn't want to get my estate if I didn't do a will. So I think that has really sometimes will convince people that they need to do a will, is kind of explaining who will get their property if they don't have that will, like just a hypothetical. But in regard to the living will, like medical treatment, that I can also from experience say that you want to have that conversation because you want to know what that person would want. When my father was dying, I had to make decisions for him. You know, did he want to get a feeding tube? Those type of things. And we had never talked about it. I didn't know what he would want. And it's really hard on the person who's making that decision. If you don't know what that person wants, you're trying to decide life and death decisions. And if you don't know, it can be really hard on the person making that decision. So I tell people that to talk to their children or talk to each other, because you don't want to put that decision maybe on one of your children. You don't want them to have to. So sometimes that can be a good reason that they'll want to go ahead and do this, because they don't want somebody else to make a decision and have possible guilt from whatever decision they make.
And we have another question. Are children responsible for their parents' debt when they die if they are the POA?
No, the POA all you are is you are handling their assets for them. You don't take on their debt when they die. No.
Pardon me for stepping away for a second. When you were talking about the difficulty of raising the issue, I wanted to share with everybody that there is a card game called Go Wish, which has different scenarios, and it's a way to introduce difficult topics, whether it's end of life care.
Oh, wow, I never heard of that.
So, and it's, I'll put it in the chat, but it's from Coda Alliance, and it's called the Go Wish game. And it gives you some springboard statements to start difficult discussions.
Oh, that's good to know. I did not know that existed. That's a great idea.
So I will put that in the chat right now. I'm a little slow, but I did want to say thank you again, Jennifer. It has really been very helpful.
I hope it's been helpful. Yeah.
Very informative.
Good. And like I said, if anybody has any other questions, they can certainly email me.
Thank you.
Jennifer, do you want to stop sharing now? Thank you very much for enlightening us.
No problem.
Thank you.